Welcome. My name is Hugo Fernandez. I'm the host here of What's Going On. And I just want to say that I'm giving myself a pass today because I got my second dose of the vaccine and I'm feeling the repercussions. One of our guests as well, Dr. Vera Albrecht and Dr. Shannon Proctor, who are both professors of philosophy here at LaGuardia Community College in the Humanities Department. And Dr. Albrecht, you're also not feeling very well, are you?
Same thing. I got my second COVID shot.
And Shannon, how are you feeling, Dr. Proctor?
I'm doing well, but I am shotless as of yet. So,
oh my God. All right. So our show today, May It Please the Court, we're going to be dealing with the issue of sexual education and government funding for that. That's why I kind of started out the show with CSN, Teach Your Children Well. So we're going to play for the first half hour, we're going to play the recording along with a little bit of a video so you can follow along. And then we'll come back and talk about the case. Take it away, Mr. Pope.
Arguments on Abortion presents the case of Bowen versus Kendrick. The edited arguments are narrated by Professor Nadine Strawson, President of the American Civil Liberties Union.
We'll hear argument first this morning in number 87-253, Otis Bowen versus Chan Kendrick.
The case that Chief Justice William Rehnquist has called this morning of March 30th, 1988, involves a politically explosive issue, sex education in the classroom. In earlier cases, the Supreme Court has recognized that adolescents have constitutional privacy rights, including the right to seek and obtain information about sex, contraception, and abortion. But teenagers' privacy rights are limited by the interests of their parents and of the state. The case at hand today tests the limits of teenagers' right to sexual information. A coalition of pro-choice organizations has challenged the constitutionality of the Adolescent Family Life Act. The AFLA, passed in 1981, restricted federal funding to sex education programs that teach teenagers only about chastity or abstinence. The plaintiffs claim that the act violates the religion clauses of the First Amendment. The District Court for the District of Columbia agreed and found the act unconstitutional both on its face and as applied. Otis Bowen, the Secretary of Health and Human Services, has appealed to the Supreme Court. He is represented by U.S. Solicitor General Charles Freed. Freed now stands at the lawyer's podium facing the bench. The seat at the left end of the bench is traditionally reserved for the most junior justice. It is occupied this morning by Anthony Kennedy, the last of President Reagan's appointees to the Supreme Court. Reagan's first choice was the fiercely conservative Judge Robert Bork, who opposed abortion rights. The Senate rejected him after tumultuous hearings. Kennedy, who was confirmed by the Senate less than 2 months ago, had been less outspoken about his views on abortion. His would be a crucial vote in this case. Chief Justice Rehnquist.
Mr. Freed, you may proceed whenever you're ready.
Thank you, Mr. Chief Justice, and may it please the Court.
Ronald Reagan was elected president in 1980 as an anti-abortion candidate. The abstinence-only movement, supported by a hard core of the Christian right, gained immediate political momentum. The AFLA set aside $2 million for the development of classroom materials to teach adolescents to say no to sex. Standard information about birth control and abortion was excluded. The AFLA explicitly invited religious organizations to participate in these programs. Solicitor General Freed claimed that the statute did not constitute an endorsement of religion.
Though religiously affiliated organizations have participated without question throughout our history in the care and counseling services funded at all levels of government in areas such as juvenile delinquency, runaways, drug addiction, physical and mental health, foster care, adoption, and aging, the district court struck down on its face and as applied as violating the Establishment Clause this act insofar as it specifically adverted to the inclusion of religiously affiliated organizations within the class of permissible grantees.
In a 1971 case, Lemon v. Kurtzman, the Supreme Court defined a standard to assess the constitutionality of a law under the First Amendment's clause prohibiting the establishment of religion. The court said that to be constitutional, a law must have a valid secular purpose. It may neither have the primary effect of advancing religion nor create an excessive entanglement of church and state. Freed argued that the district court had incorrectly applied the Lemon test to this case.
The district court's standard and reasoning was such that I think no one in this court, not us, not the plaintiffs and their amici, defended. The district court found a valid secular purpose here, and properly so, but found that the act had the primary effect of advancing religion, thereby failing the second prong of the Lemon test, because, and I'm quoting here, of its use of religious organizations for education and counseling of teenagers on matters relating to religious doctrine. We pressed on the district court and renew the argument here that the correct standard for determining whether a law has the effect of advancing religion has been set out many times in the decisions of this court, and perhaps most neatly in the decision in Hunt v. McNair, where it was said that aid has the effect of advancing religion if, and I quote, it flows through an institution in which religion is so pervasive that a substantial portion of its functions are subserved in the religious mission, or if it funds a specifically religious activity in an otherwise substantially secular setting.
Justice Sandra O'Connor pressed Freed to make his point.
What do our cases tell us we should do if we think a statute might be constitutional on its face but not as applied? And if the evidence is there, establish that.
That it is constitutionally applied.
That it is unconstitutionally applied.
If it's unconstitutionally applied, then I think the question becomes, is it capable of being constitutionally applied? Well, plainly, by answering the first question in the affirmative, then what must be done is that the relevant authorities must be directed to cease applying the statute in an inappropriate way.
Justice Kennedy was curious about the facts in the case.
Were there any findings in the district court where you would concede in this case that there were some unconstitutional applications?
In our brief, we said that there were some departures, but I don't think, Justice Kennedy, it's correct to say there were any findings of any sort in the district court. This was on summary judgment, and what we had is a sort of comprehensive wave of the hand in the direction of some of the often quite disputed evidence. But that I don't think constitutes conscientious fact-finding, such as Congress is entitled to before one of its statutes is struck down.
The AFLA, Freed concluded, is plainly constitutional.
There is one particular equation which the district court leapt to, which must be corrected, and that is the notion that the activities here are specifically religious because the counseling and the care which would be given by the religiously affiliated organizations, though for a proper secular purpose and though without any reference to religion, is for those religious persons inspired by their own religious convictions. That surely is a novel and very dangerous proposition, and one which I don't think can be seriously entertained.
It is the rule for oral arguments that each party has 30 minutes to present the case. Occasionally, two lawyers share that time. General Freed yielded the podium and the rest of his time to Michael McConnell. Chief Justice Rehnquist.
Mr. McConnell, we'll hear now from you.
Thank you, Mr. Chief Justice, and may it please the Court.
Michael McConnell, a professor at the University of Chicago, represents a co-appellant in the case, United Families of America. McConnell is confident in his argument.
The single most important point I wish to make this morning in my brief 10 minutes is to clarify precisely what the legal question in this case is, because I agree with Solicitor General Freed that the many factual allegations are not appropriately before this court on an appeal. The legal question is whether otherwise qualified private organizations must be excluded from the Adolescent Family Life Program solely on the basis of their religious affiliation or inspiration. Our position is that the Establishment Clause does not require and the Free Exercise Clause does not permit religious belief or affiliation to be the basis for a civil disability. AFLA grantees must be judged according to their conduct and performance and not according to their beliefs.
The Supreme Court has consistently held that public funding of parochial schools violates the First Amendment. Justice O'Connor asked McConnell if parochial schools would qualify for public aid under the AFLA.
Do our cases support the view that public funds may be used to teach secular subjects in parochial schools to teenagers?
No, Your Honor. This Court has consistently held that programs of aid to parochial schools, which are predominantly sectarian institutions, in most of the cases before this Court, over 95% of them being sectarian, is not a neutral program of secular education. The reason for that seems quite evident. Even though the description of the program, private education, may sound neutral on its face, in fact, everyone understands that the institutions involved are predominantly, almost exclusively religious.
Does this statute, in your view, contemplate that parochial schools, for instance, could be grantees in these programs?
I suppose so, Your Honor, so long as the class of potential grantees includes a much wider category than just parochial schools. The problem with the parochial school case is that the aid was targeted. But it would contemplate that a
parochial school, for instance, could be a grantee and teach these subjects in pregnancy prevention with federal funds.
None of the grantees have, in fact, been parochial schools, but I'm not aware of any reason why they would be excluded as one of a much broader range of potential grantees under the program.
And it's your position that, as so interpreted, it can be upheld under our precedent?
Yes, Your Honor.
McConnell insisted that their religious beliefs did not prevent educators from administering sex education programs neutrally.
It seems rather clear to us that the way in which to be neutral in these matters is to insist upon objective, secular, neutral criteria for the selection of grantees, and not to either grant a grant to someone because they're religious or to deny the grant to the same organization because they are religious. How they are going to perform the secular functions of the program has to be the key. That is the way in which we can see through to neutrality in a case like this.
McConnell's interpretation of the First Amendment provoked more questions from the bench.
It is our belief that it is not excessive entanglement for a program to be administered in a way so as to avoid the more serious constitutional violation of a flat-out discrimination on the basis of religious affiliation or belief, which could not be a plainer violation of the Free Exercise Clause. If Congress had passed a statute that says grants are going to be available to all voluntary and charitable organizations except for those who have religious beliefs, this Court would not have any hesitation in declaring such a statute unconstitutional, either under the Free Exercise Clause or under the Equal Protection component of the...
But Mr. McConnell, is that different from a grant that says it can go to religious organizations provided the religious beliefs are of a certain kind?
I do believe that those are quite different situations, and it is simply not true that this program gives grants only to organizations with beliefs of a certain kind. An organization that believes in abortion, for example, is perfectly eligible to put on an AFLA program. It simply may not urge or facilitate abortions in the context of the program itself. It is free to do with its own money and in its other operations whatever it cares to do.
The warning light at the lawyer's podium signals McConnell that his time has expired. Janet Benshoff, a lawyer for the American Civil Liberties Union, argues for the appellees. Chief Justice Rehnquist welcomes her to the podium.
We'll hear now from you, Ms. Benshoff.
Mr. Chief Justice, and may it please the Court.
Benshoff is an experienced lawyer who has been involved in many reproductive rights cases before the court. She speaks with passion.
I would first like to address the answer to Justice O'Connor's question because I believe that the answer the solicitor gave was dead wrong. Her question was, what do we do when we're showing some unconstitutional applications of a statute, which most certainly has happened in this case, probably more than any other case reviewed by this court? Well, this is a facial challenge, and facial assessments have been the rule of this court even when statutes have been applied for 10 or 20 years, and even when trial courts have upheld them on as-applied grounds.
Justice O'Connor asked if the law was inherently unconstitutional.
Ms. Benshoff, do you think that the statute would survive, in your view, if there were additional statutory or administrative prescriptions against the misuse of government money for non-secular purposes?
No, I don't think so for three reasons. First of all, this is a unique demonstration project by Congress. They wanted to try something new, and they said there are certain limitations of the government in dealing with moral issues. Let's try something new. And it calls for religious participation explicitly in 4 places.
Justice O'Connor and Janet Benshoff discussed the letter of the law.
Now, we argue that the statutory language requires all applicants to involve religions, even if you're secular. And although this is
as appropriate.
Yes, although this is disputed by the government, the district court, HHS, grant applicants themselves, and the 1984 Senate Committee all agreed with our interpretation. However, our argument on the constitutionality of the statute doesn't hinge on whether it's mandatory or optional. It is absolutely clear that religious organizations are eligible for grants and they're listed as desirable participants.
As appropriate.
Well, we agree that it's as appropriate in the delivery of their services, not whether or not they want to have them. We think it's whether or not where they want to put them in. And every applicant we investigated, secular or religious, had it in there, and we put that evidence before the court.
There can be no doubt, Benshoff said, about the motivation of the law.
In fact, if you look back at the 1981 legislative history, they said, what's a model statute under this program? A model program. And a model program was one where public school children would be released from school to go to churches to receive federally funded sex education. That was the kind of model program Congress envisioned. So as you see, there was certainly a joint endorsement between religion and churches that Congress envisioned.
One of the justices asked if Benshoff challenged the promotion of sexual abstinence itself.
You don't contest, I don't think, that Congress can lawfully adopt as a purpose encouraging and inculcating in the young sexual self-restraint. That's not your...
Absolutely not. Of course they could adopt self-restraint.
Right,
they just can't do it by ways of, for example, one grantee of teaching young girls to pretend that Jesus is their date.
Benshoff directed the justices to the record in the case.
I would like to point out that the government admitted below all of our expert affidavits from religious theologians saying that these values, although could be secular, when you put the values of chastity, intercourse, masturbation, marriage into the hands of religious authority, it's going to be very hard, and I think we proved impossible for religious organizations to teach them in a secular way.
Benshoff was asked if she made a distinction between religious persons and religious organizations.
You can have other organizations who have the opposite values that can teach those values, even if the people that are teaching them are religiously motivated.
Well, obviously,
that is, if they say, use contraception or use birth control or use abortion, that's all right.
Obviously, our public schools teach a lot of values, as we all know that. We also feel there's a lot of interplay in the public school situation that leads to democratic pluralism, different school boards, public libraries, no dictates on the care. That's a good example because I think if the public schools want to teach, for example, AIDS education, and abstinence would be a major factor in that. But if they would give that to religious authorities, and religious authorities would not mention condoms, or, as some of our programs do, say such things as condoms cause birth defects in order to discourage teenagers from learning about condoms, that would certainly be a religious rule that prevented secular teaching on abstinence. We are not saying that chastity can't be a secular value, certainly that it certainly can be, and there are very good secular reasons to teach it. But in the hands of religious authority, there's not just a possibility that it might be misused. We've certainly proven that it has been misused.
Benshoff argued that it is impossible for religious organizations to teach religiously sensitive values in a neutral way. She encountered resistance from the bench.
Do you agree with the district court when it said that to presume that counselors from religious organizations can put their beliefs aside when counseling an adolescent on matters that are part of religious doctrine is simply unrealistic?
Absolutely, because every religious organization that got funding when we did Discovery was operating under religious dictates, whether they were religious themselves or not. For example, in St. Margaret's Hospital, all the employees of this program had to sign a statement that they would follow religious dictates. One midwife who was counseling teenage girls, for example, who asked her, may I have sex during pregnancy? She thought that was a medical question, and she said yes. She was chastised and almost lost her job because she was told that she was supposed to give a religious answer to the medical question. So, certainly funding most hospitals would be absolutely constitutional. But if you funded a hospital run by the Jehovah's Witnesses to counsel for a hemophiliac ward, in which they would counsel against blood transfusions and not offer them and not send them elsewhere, that would raise some very serious Establishment Clause questions.
What if the chief executive officer of a sectarian hospital was personally very religiously motivated? Would that prevent him from playing any part in the administration of a grant that the hospital got?
Absolutely not. We're not talking about the personal beliefs of people. Obviously, public school teachers may be very religious.
But only people have beliefs in the long run. I mean, it isn't the buildings don't have beliefs. Organizations without people don't have beliefs.
But people operate under religious dictates that they may or may not believe in. The evidence of this case shows that many of the employees in these programs did not operate under the beliefs that they were forced to force on teenage girls who didn't share those beliefs either.
Benshoff concluded with these words.
For over 200 years, this country has ensured religious liberty, protected religious pluralism, and minimized political divisiveness, and this is a very competitive program, by rigorously enforcing the First Amendment. By finding the Adolescent Family Life Act unconstitutional, this court furthers the original intent of the framers that religious instruction and indoctrination are not within the scope of Congress's power to tax and spend for the general welfare. Thank you.
The justices waited until the last day of the term, June 29th, to announce their decision in Bowen versus Kendrick. Justice Anthony Kennedy, who had provided little information about his stance on abortion during his confirmation hearings, cast the decisive vote. The court voted 5-4 that the AFLA did not violate the Establishment Clause of the First Amendment. Chief Justice Rehnquist wrote the majority opinion. The AFLA, he said, has the valid secular purpose of promoting sexual abstinence by teenagers. Rehnquist noted that the services provided under the Act are not religious in character and that religious institutions are uniquely well qualified to carry out those services. It is clear, Chief Justice Rehnquist wrote, that the AFLA takes a particular approach toward dealing with adolescent sexuality and pregnancy. But again, that approach is not inherently religious, although it may coincide with the approach taken by certain religions. Justice Harry Blackmun had been quiet during oral argument, but the dissent he wrote was eloquent. He said he had no doubt that the AFLA violated the First Amendment of the Constitution. Justice Blackmun agreed with the district court that asking religious organizations to teach and counsel youngsters on matters of deep religious significance, yet expect them to refrain from making reference to religion, is both foolhardy and unconstitutional. The effect of the law, he concluded, was to block young women's access to information essential to their reproductive decisions. The religious right and the abstinence-only movement have gained political strength in the last decade. Today, over a dozen curriculums preaching abstinence are sold around the country. The most popular and controversial one, Sex Respect, has been adopted by more than 2,000 schools. Supporters argue that chastity is the only response to the social and moral evils of teenage pregnancy and motherhood. Critics respond that chastity for all is unrealistic and that ignorance is dangerous. With the highest teenage pregnancy rate in the industrialized world and social tolerance for unwed, uneducated mothers running low, the debate about adolescent sexuality is unlikely to subside. It illustrates that in the abortion war, the struggle is for the control of women's souls as well as their bodies.
Arguments on Abortion is a production of the Earl Warren Bill of Rights Project of the University of California, San Diego.
All right. So before we start talking about the case, I wanted to just go ahead and do a station break. You're watching What's Going On. I'm your host, Hugo Fernandez, here on LaGuardia Web Radio, WLGR. And today on May It Please the Court, we're talking about Bowen and Kendrick versus Kendrick. And my guests are Dr. Vera Albrecht and Dr. Shannon Proctor of the Humanities Department's philosophy programs, who both teach the philosophy of law. And doctors, could somebody give, in 25 words or less, sum up what was going on there? Because it was one of those times where I felt very nuanced what was going on.
I think that one major distinction to point out is that in the First Amendment, you both got that Congress is not allowed to either support or repress religious expression, right? And that was a huge condition of this case, is whether or not, if they had barred religious groups from teaching the sex education, whether that would violate it, or whether if they allowed them to teach sex education, if that would, go against the First Amendment. So that would be one major issue. I don't know, Vera, if you want to add on there.
Well, that's pretty pointed. I mean, the question was if it violates the First Amendment to have religious organizations teach sex ed. One may just on the side throw in the question, like on a common sense view, is it a good idea to have religious institutions teach sex ed? And the question, big picture, was, of course, can they teach it in a way that does not promote religious ideas, that promotes secular ideas of abstinence?
And well, I remember that the justice, I think possibly Sandra Day O'Connor, who was asking, so, can the religious, institution teach, this curriculum? Or what if you had, maybe it was Rehnquist who was talking about, let's say you had a secular person teaching at a religious institution, or a religious person teaching at a secular institution, and how the impacts were of that. But for me, it kept coming down to the fact of trying to say that inherently religious institutions cannot teach sex education by virtue of the fact that they do not support or allow a lot of different practices. For example, sorry, go ahead, Dr. Proctor.
I'm sorry. It wasn't just that they don't. So it's not that they wouldn't say promote the use of sort of contraception or discuss abortion. I think it was more if they are talking about abstinence only kind of education, or if they're really pushing chastity, not only like that's allowable, but that cannot be taught as like the reason why that's a good thing is because of religious.
So. Yeah.
And while we didn't get a lot of examples, the examples I could discuss in some of the opinions, it was clear that almost every religious institution that was a part of this program was absolutely commingling the ideas with the theological beliefs, which is certainly a clear violation of the First Amendment.
And the Constitution, and by virtue, they would not be eligible for federal funds.
Exactly. It's about whether they should get federal funds to teach this to public school children. So if the religious institutions do it this way, if the parochial schools do it this way, is one thing. But if they take over the sex ed and receive funds for it, that's a different issue. Then, in a way, if that takes tax money, then the state funds religion, and that it's clearly in violation of the First Amendment. The question is also, can it, of course, abstinence can also be a secular value. And that was a big part of the decision in the end. Well, it can be a secular value, but it's also a question as to whether, if everything else is cut out, can religious institutions properly teach it if they just narrow things down to just one value?
Yeah. While I was listening, I was remembering back when I took sex ed in high school. I think it was in the same year I took driver's ed. Interesting that they would put those two things together in the same year. And by the way, both of them were taught in Florida. When they run out of space, they set up these buildings outside, like almost like Qantas huts. And both of them were taught in those huts, and I don't remember which. And I just remember being in that class and, being very provocative and asking my teacher a lot of questions. And I look back at it now and I'm thinking to myself that, everybody knew that, I had no practical experience in what, because, like they say, the ones who talk about it don't do it. But, I just find it fascinating. I was in Florida and it was being taught. I think I remember diagrams and things like that, but I don't know. I also find it very perverse that not so much in women, but young men are 19 is that they're peaking, right? And at the same time, we're telling them don't engage.
We have students listening to this.
Well, no, I'm talking about this is physiognomy. That at the age of 19, that's when most men are at their peak for as far as fertility is concerned, right? And that whatever that dry, then that you're shaking your head, Doc. Do we need a biologist on the show?
Yes, we do. We definitely need a biologist.
I'm not just. I just think, personally, I think 19 is way too late to teach kids sex ed. I mean, it's
past high school age anyway, so that's beyond the realm of this court case.
Well, I'm not saying that. I mean, obviously, you want to do it. You want to get it before they peak, right? You want to hit people up, but I'm just saying that, the physical drive is there, and at the same time, they're getting these messages: don't engage. If chastity is that lesson, right?
There was a really
and how
interesting.
It's just like a formula for failure.
Right.
There was an interesting article this week in the New York Times about this abstinence-only movement that was so big, I guess, kind of in the mid 90s particularly, and how so many of the people who wrote like the most popular books on this sort of like, people would get the ring and take the chastity pledge, and like so some of those authors have removed their books from the marketplace. Like they feel like they've just kind of contributed to this notion of shame and sort of self-hatred connected to sexuality. I found that interesting to see that there's lots of regret about those movements that were probably coming out of some of this decision too. I also wanted to say a question I thought I heard O'Connor asked that I didn't feel like the lawyer responded to is I felt like she was asking, well, in a sense, why shouldn't parochial schools get tax money for non-religious courses they teach, right? So if you're teaching geometry, I felt like that was an extremely good question. Like if we believe that a religious institution can remove their religious practices from a course, well, why shouldn't taxpayer money go to that? And I felt like the lawyer just completely evaded that.
Are you talking about the Ben Shoof?
No. The first I can't.
You're talking McConnell.
It was
Freed.
sure McConnell. I'm not sure. Yeah, one of the two of them.
But the question is,
I think one of the answers was that in some cases you can say the religious institutions can keep the religion out of it. And I mean, geometry or math or, some other fields, maybe not all, but science or maybe literature. But this particular case, this is sensitive to to religious belief. Sexuality is sensitive and intertwined. Yeah, I like the move, exactly. It's intertwined with religious beliefs. And this is the intertwined. And this is why it will be hard, and of course, Ben-Shuf argued impossible for religious institutions to keep the religious belief out of this particular education. And yeah, they should be funded for, teaching math or something. But this is impossible. That was her. I'm not sure if that was the answer specifically to that question, but that was her claim, that she actually claimed that it was impossible to keep the religious belief out of this particular education.
The philosopher in me wanted to push on impossible, because of course it's not impossible, but certainly in practice it did not ever occur.
Maybe, and actually, if I just may go over to the court asked, well, is there really a distinction? The distinction between a person and institution, and I think the court claimed, well, it's only people who hold beliefs, not institutions. And of course, beliefs don't hold beliefs, but beliefs can impose their beliefs or their dogma on their employees. And the example that Ben-Shuf gave of a midwife who answered a question and then was fired because she was supposed to be, in the religious kind of, was supposed to uphold beliefs, and she thought it was a medical question, and answered it on a medical basis, but it violated the religious tenet of that institution. And so far, of course, institutions can require their faculty to uphold the religious beliefs, which might be easy in a math class, but not so in a sex ed class.
Well, and I wonder how that fits with these later Citizens United decision, where we get that corporations are people. And if we are, so I mean, obviously a much later court case, but I thought that was indeed almost a slimy way for the justices to address this, was to suggest that yes, institutions don't have belief. The Catholic Church has beliefs. Religious institutions certainly have doctrine, and not that far afield. Sorry, Hugo. Yeah, go.
Yeah.
No, I mean, I'm just, it's just interesting listening to this. So again, I would go back to the 25 words or less. That what's the Solicitor General asking of the court? To strike down the decision of the appellate court, right?
Yeah.
And then that appellate court stated what? That religious institutions can't teach.
They said the law was unconstitutional on its face and in its application.
Mm-hmm.
Okay. Yeah, when you were talking, one of the things I was wondering, like, so could you teach evolution in a parochial school? Like, let's say
I went to Catholic school. I went to Catholic school for 13 years. We absolutely learned evolution. But the Catholic Church doesn't take a stance against that.
Right. Others do.
Also, we had a doctor. We also had a doctor come in at our first sex education in 8th grade. We literally had a physician come in and teach us about it. So,
do you remember their policy about how do you handle sexuality? For example,
we were all allowed to write little questions down on a card, give it to like a little index cards. No one had to put their name, so we could, and he answered from a medical perspective. Now, when I went to high school, an all-girls Catholic high school, they were a little more conservative. And certainly we weren't allowed to, like in a debate class, we were not allowed to debate abortion. There were certain these are core principles, even if it was an English course. But definitely many religious or parochial schools, teach science in the way that it would be taught at any sort of public institute or, public high school.
Right.
Actually, I went to school in Germany. I also went for many years to a Catholic girls' school. And I have to say, we got sex ed by biology, but this just on the side, we had a Jesuit teacher who was the most fun and the most open-minded biology teacher. And he was so open that the school in the end did not permit him anymore to teach religion because it wasn't, dogmatic enough. So it's just.
Yeah, you expect that of a Franciscan, maybe.
But
no, I've had Franciscans. Okay, I don't want to get in trouble for it. Anyway, they're lovely, lovely people. The Jesuits are very philosophical, right, and kind of open.
But there's a lot of being strict.
His field was biology, so, and he was. I think first he was a biologist. Second, he was maybe a philosopher, and he was the person to go to for all questions. He was like, back in the days, he was Mr. Google.
He was, the guy who takes the question,
knows
like,
everything.
Can God make a rock so big that he can't lift it? That guy.
Yeah. So, but what is kind of, I don't know. I'm just amazed that this still stands, that still has standing. To get back to our case here.
Right.
And if you say you promote some value that is a secular value, that's okay. But if you leave out relevant information, it's also kind of very biased. So even though some portion of your view or education may coincide with something else, if you leave out something, say if a school, if a biology class would teach everything except evolution, if something is purposely left out, it's also creating a bias. And if the sex ed leaves out contraception and abortion in particular, that creates a bias.
But that goes on in public schools all the time. I guess that would be where you wouldn't have to focus on religious institutions teaching these courses, because there's certainly, it's state, I think it's state, and maybe it's even smaller, like municipalities, that get to decide the content, right? Like the school board's getting to decide what's taught. And there are many high schools still in the United States where they do not teach, where it is abstinence only based, where they are not, and they're still getting state funding because they're not doing it from a religious perspective.
Right. Even though the people who are promoting it do have religious beliefs. By the way, we're moving into the last quarter hour, and this is at a time when we will take questions. Dr. Carr is actually watching and listening, and she is saying she's laughing out loud because she says she had no sex ed at her Catholic girls' school, and there was a chastity rally in the 8th grade in.
Oh my!
This is 1993. She's saying too. So these are the Clinton years. But I don't know. I guess one of the things. But so folks who are watching and listening, if you'd like to send us some questions, we'll ask the doctors. It's for me. It's like when there's an absence of information, I know where people go get that information. They go get it from their friends, and sometimes they get lucky. What?
The internet.
Well, now we have the internet, so you could watch videos. I remember in college when I was kicking around and had nothing to do, like undergrad, junior college, I'd go up to the library where you could rent films, and they had these Swedish films on sex education. And, like, people were like spinning around on a bed, and I'd just sit in there and watch. Yeah, can you imagine? And people were walking. I don't know what people would thought if they walked by. I watched that, and I was watching some 30-minute documentary on the beatniks. Those were the two films that I rented the most. But in the absence of that, you go if you have the guts to ask.
Yeah.
So,
and now you don't have the guts to ask, right? Like, as long as you have access to a reasonably high-speed modem, you can find out all of this and more.
Unless your parents block it.
But also, ignorance or misinformation. Ignorance or misinformation. Don't forget that, asking around, these kind of what you can't talk about, first of all, becomes more interesting. And second, there is a lot of misinformation going out. And that can also be kind of counterproductive. If you want to reduce teenage pregnancy, it can be counterproductive to get, incorrect information out.
I think it makes me come to the question of, at the very least, this should have been studied empirically. And I know there's been some studies about this to figure out, was this even achieving, if there are these governmental goals of reducing teenage pregnancy, reducing teenage sex, if those are legitimate governmental goals, did these programs do it? And I think the fact that there was so little investigation of that tells you something about the motivations behind this act and this ruling, is that it is not that there's something more going on here that needs to be explored. And I think it does have a lot to do with traditional gender roles more so than.
Thank you.
Yeah. So I'm rambling.
Well, are you saying because the folks who find themselves in these roles are predominantly men, and there are fewer? I mean, what's fascinating is, Sandra Day O'Connor was appointed by Reagan. That's kind of a bizarre thing. The first woman,
reasonably conservative,
she voted with the majority in this case.
Yeah, that's
so.
And I think, like, what I'm trying to say is, I think that if you're really trying to reduce teenage pregnancy, there is lots of empirical evidence that would say teaching about contraceptive use and having conversations about that is tremendously valuable toward reducing teenage pregnancy. And if that's not what you're teaching, and if a lot of these programs were tending to focus on women's or young girls' responsibility is to prevent men from becoming aroused by them, right? That they were like the lust provokers, and it's their responsibility to prevent that. I think it just says that the stated state goals were not, I would not take those to be the true motivating factors of why this law was created.
I think that.
Thank you. And there's actually also studies, and now I should have looked that up prior to this because I can't quote it, but studies that the whole abstinence only program is also counterproductive. That actually teenagers who start with this, who have these, pledge, they are more likely, and again, I should be able to quote this and I'll be happy to look it up, but that this is not really working anyway. So,
well, it is fascinating that, people don't want to look at the data.
Yeah.
They're willfully not looking at, because for them, dogma trumps data. And this is not unique. This is not just unique to, like, for example, sexual education or abortion rights or, reproductive rights. I mean, we see this happening with immigration. We see this happening with the war on drugs. Interestingly, war on drugs, Reagan's, Nancy Reagan's say no to drugs, which some folks said was working. But if you look at what's going on, the ramifications of the drug war in the United States, it's not working. So I find it fascinating that, willful, refusal to look at data. And, one of the, I don't know if you two are picking this up as we go through these cases, but how basically based on whoever's in that court, how, in collusion with the legislators, or let's say whoever's in the administrative office, it's the move forward is glacial. And many times it's like back and forth. It's like one step forward, two steps back. And it's very frustrating.
Yeah.
No, go ahead.
I was just going to say, especially when there seems to be issues that there's a lot of agreement amongst the population, right? Amongst the citizenry.
Right.
Yet we still can't sort of make real movement.
Yeah. Also, I mean, when actually society kind of moves one way and the court moves another way, and we've seen this just with the recent Supreme Court being stacked by ex-President Trump, that the last two Supreme Court nominees are anti-abortionists, and some people, anti-abortionists have their hope up that it will be kind of reversing Roe v. Wade. So this goes actually contrary to where society goes. And I mean, of course, empirical evidence also has it that in, societies, say, countries where abortion has been legal, where sex ed informs, people, there's a lot less abortions and a lot of pregnancy prevention more than we have it, because ignorance just really leads to pregnancies.
This elevation of doxa over, data, or dogma over data. And it's not as if I think empirical data will always give us, I'm a philosopher. I do think that there are certain issues where we really need to engage it at maybe a level above or behind that. But in many of these governmental causes, it's both understandable because I'm cynical, but it's still surprising how little especially if the main reasoning of the court is this is connected to a significant or important governmental interest, well, then it should be able to be proven that it is supporting that governmental interest. And that requires empirical data.
And I mean, after all, ultimately, sexuality is, first and foremost, a medical issue. I mean, or biological issue. Okay. Maybe something else. I don't want to, discard all the romance here, but I'm in for it.
Well, sometime we should have Dr. Love on sometime, and she can go into the many types of love. There's at least 5.
Right, but I mean, I think for the purpose of legislation, let's put it this way: biological medical issues.
Oh man, I'm just gonna laugh about that.
Here's the
on that note,
I
would like to just make one cynical issue, just a little cynical issue. I mean, if you look at the Supreme Court, it's a bunch of old guys. I guess it's easy for them to think that abstinence works. Maybe not so much for teenagers, as a biological issue.
Yeah, we're moving into the last 5 minutes, so I guess I'll give you an opportunity to have the last word, or anything else you want to say hi to anybody. Say hi.
Definitely hi, Dr. Carr. Good to see you.
Hi, Dr. Carr. Yeah, thanks for listening in.
Any last words about this?
I guess again, I'd like to say that, thanks for allowing us to have these conversations. It's really been great. This case, I found this case so fascinating. The one thing I didn't point out that I wanted to is when we were listening to Rehnquist's final words, where he was saying at the same time that religious institutions are so well suited to do this work, but of course it's not because they would do it religiously. I just found that mind-numbing. It makes no sense. These are the best places to do it. Well, why?
Yeah.
I guess
I agree. I also think, this was a case in the 1980s, but even then it's kind of behind. And now for it to have standing now, and by the way, with the way the Supreme Court looks now, I don't have any hope that this might be, overturned anytime soon. And interestingly also, this case was decided by the one Justice Kennedy, who was new on the court and who was kind of an anti-abortion guy, who ultimately made the decision here. So,
and he never tipped his hands during the Senate hearings, and he learned that lesson from Bork, who, faced a lot of backlash. Bork was also in trouble because Bork is famous for the Saturday Night Massacre, where he fired a bunch of people in the Justice Department when Nixon was trying to stave off eventually being, impeached for Watergate. Mm-hmm. So the firing of the independent prosecutors and all that stuff. Mm-hmm. It's all entwined. It's a mess. Just so you know, the next case we're going to go over is Webster versus Reproductive Health Services, which deals with a Missouri law which tried to tackle, the idea of declaring when human life begins at conception. So we'll pick a date for that.
Philosophically interesting, really.
Yeah, you guys will have some fun with that. All right, but we're out of time. So I just want to say thank you to my two guests today, Dr. Vera Albrecht, Dr.
Thank
Shannon Proctor, both from the Humanities Philosophy program who teach, the philosophy and the law. Also want to thank our guest, Sherry Carr. Sherry's saying it's her pleasure. She's saying for me to check my auto mode. My story about the chastity rally wasn't sent through. Stopped by your auto moderator. Interesting. So there's even something going on in Twitch here. Little did we know. But the show is, may it please the court. And I've been your host today, Hugo Fernandez, on my, derivative of my show, What's Going On, here on LaGuardia Web Radio, WLGR. Thanks everybody for watching. Thanks for listening. Come back for the next case. And Mr. Pope, please take us out. Thanks.
Thank you. Bye-bye.